Meeting of the Speech Language Pathologists and Audiologists Advisory Board to order at 10 o'clock. And welcome everyone to the meeting. There are a couple of things just to remember. Keep your microphone muted if you're not speaking. Keep your camera on if you're a board member so that we can make sure that we maintain a quorum at all times. And then another thing that I'm terrible about remembering is each time that you speak, it's asked that you say your name. That helps for the record, and just, you know what it's like when we use Zoom and people are blocks on a screen. That way we know for sure who said something. So please just remember that if you are wanting to say something. And welcome to some new board members today. We have 3 new board members. That's great to get 3 new people all at once, and we'll be doing some training this morning to onboard our new folks. So I'm going to ask each of them just to tell us a little bit about themselves and how they relate to the professions and to this board, their interest in serving on this board. So let's start with Dr. Perkin first. Dr. Perkin, tell us about yourself.
Over 15 years of experience. I also hold a doctorate in organizational leadership and healthcare administration. I'm honored to be here and look forward to contributing to the board's work and strengthening our profession.
Great, thank you. Dr. Tellis.
Hi, my name is Robin Tejas. I'm a licensed audiologist. I currently practice. I'm in San Antonio. I work at University Hospital, or the Bexar County Hospital District. My professional sort of area that I'm passionate about is pediatric audiology, but I'm also serve as our clinic manager right now. So supervise about 10 licensed audiologists. We have a lot of students. So that's really why I'm interested in just kind of serving the population and also just the field of audiology in general by serving on this board. So
Great, thank you. And I made a note, it's Dr. Tejas, yes?
it's okay. I'll answer to either.
I'm an SLP, I wrote it in IPA, so. Ms. Weems.
Good morning, I'm Norma Weems. I have 27 years of education experience. Currently, I am a director for 5 small rural school districts. And I also currently have hearing aids. I am hearing impaired. So I am excited to be part of this group to learn more, not only for myself, but also for the students that I serve in my small and rural communities.
Okay, great, thank you. Welcome to our new members. We're going to start off this morning with some government training by our Assistant General Counsel, Chris Funderburg. So Chris, are you ready?
Real quick, Sherry, can we go back to the roll
Yes.
call, please?
Oh, I'm so sorry. I completely forgot roll call. So Angelica, would you call the roll and be sure we've got that quorum?
Yes, ma'am. Stacy Poteet,
Present.
Dr. Ana Maria Montanes, Dr. Eduardo Perkin,
Present.
Dr. Robin Tejas,
Present.
Norma Weems,
Present.
Sharice Andrews, Miss Andrews, can you hear me? I'll come back to her. Dr. Shauna Jackson. I didn't hear you, Miss Jackson.
Present.
Okay, perfect. Judica Meda. I'm going to try Miss Andrews again. Sharice Andrews. Okay. And presiding officer Sherry Cyprian.
Present.
You have a quorum.
Thank you. Okay, now we're ready for Chris to do some general training for us. Chris?
Thank you, Presiding Officer Sen Cyprian, and also to the rest of this board, especially to our new members. We greatly appreciate your willingness to help the department's regulatory efforts in this profession. Just wanted to make sure, can everyone see a slide titled Speech Language Pathologist and Audiologist Advisory Board? Thank you. I'm Assistant General Counsel Chris Funderburg. I'll be going through the open government training the department is required to give to the board members each year. The training covers 3 statutes and each require transparency in government and public participation. These statutory mandates impact the function of each advisory board associated with TDLR, hence this presentation. Before I begin, I'd like to say that it's been a privilege to serve as the Assistant General Counsel assigned to the Speech Language Pathologist and Audiologist program. It's with some sadness that I have to say that I've been reassigned, though that sadness is tempered with the knowledge that this profession will be in excellent hands on the GC end. Elizabeth Salinas Stripmatter will be your Assistant General Counsel going forward, though I will be available to assist during the transition, and I'll still be the AGC assigned to the rule package that we'll discuss later during this meeting. So the first statute that we'll discuss is the Open Meetings Act. While it's important to be familiar with all 3 statutes and their purpose, the Open Meetings Act is the most relevant to your duties as members of the Speech Language Pathology and Advisory Board. So that's the focus of our presentation, though all 3 are, the second is the Administrative Procedure Act, also called the APA, and the third is the Public Information Act, also referred to as the Open Records Act. We'll start with the Open Meetings Act. This is in Chapter 551 of the Government Code. The OMA requires that meetings of government bodies be open to the public, and there has to be notice ahead of time to let the public know what the meeting will be about and where and when it will convene. The courts have held that the requirements in the Open Meeting Act are mandatory and to be liberally construed in favor of this policy of open government. There are 3 key terms associated with the Open Meetings Act: quorum, deliberations, or alternatively discussions, and meetings. We'll start with quorum. A quorum is a majority of the members of the advisory board as fixed by statute or rule. A quorum of a governmental body, including an advisory board or committee, must meet in order to take an official action. The next term, deliberation, or alternatively discussion, is the second key concept. Deliberation means a verbal or written exchange among a quorum of a governmental body or between a quorum of a governmental body and another person concerning an issue within the jurisdiction of the governmental body. And the third term, meetings. A meeting occurs anytime a quorum of a governmental body engages in deliberation regarding public business or public policy over which the governmental body has supervision or control, or anytime the body takes formal action. If the governing body takes formal action, which requires a quorum, or if the quorum engages in deliberation, either occurrence is classified as a meeting. Once that threshold is reached, the notice requirements of the APA attach. And now we'll move into the concept of notice. The Act requires advance written notice of the time, date, place, and subject of each meeting held. TDLR provides this notice in the form of an agenda. Notice must be filed with the Texas Secretary of State at least 7 days before a meeting and must be posted online by both TDLR and the Secretary of State. A board or committee may not engage in discussions about a subject not included in the agenda. This is why the board cannot engage in back and forth deliberations with public commentators, as the subject matter of that discussion is a variable and could not be specified in the agenda. A relevant follow-up question: what about social functions, conventions, and workshops? If board members engage in a verbal or written exchange about an issue outside the jurisdiction of the governmental body, it is not a deliberation. Thus, the public doesn't have to be notified about the deliberation, and that deliberation doesn't have to be an agenda item. If 5 members of the board meet at the grocery store and discuss the price of eggs, this isn't a meeting that requires notifying the public. Or if during the meeting, the board deliberates on where everyone wants to go for lunch, the lunch discussion doesn't need to be an agenda item. Keeping in mind that a meeting occurs whenever a quorum of a governmental body engages in discussion about an issue within the governmental body's jurisdiction. Can members ever meet in an informal setting without violating the Open Meetings Act? Yes. Members are free to engage in conversations that is incidental to the event. However, the discussion will be subject to the Open Meetings Act if a quorum of members is involved and the members either engage in a discussion or make decisions about the board or committee business or take formal action. Some key points to remember. Always be aware of any situation occurring outside of a properly noticed meeting in which a quorum of members is present or engaged in a discussion. Do not engage in substantive conversations relating to board or committee business or policy when a quorum is involved and you are outside of an officially noticed and scheduled meeting. And also, beware the walking quorum, which we'll discuss further. A walking quorum occurs when fewer than a quorum of members engage in a discussion about official business and then communicate those discussions to other members. While fewer of a quorum of members participate in the initial communication, subsequent communications with other members will result in a quorum discussing official business outside of a public meeting. Here's one example. On a 5-member advisory board, 2 members exchange phone calls and emails expressing thoughts on an upcoming rule change and exchange research that they have individually performed regarding the issue. One of the board members then subsequently forwards the exchange to another member. The members have now engaged in a walking quorum by engaging in a small group discussion outside of a properly noticed board meeting. Walking quorums can occur during conference calls, video conferences, hallway discussions, emails, text messages, and other new technology. The walking quorum concept, combined with the newer technologies such as X, or formerly Twitter, Facebook, and instant messaging, raise new issues about meeting and compliance with the Open Meetings Act. Here's some best practices to avoid a walking quorum. Members should not meet in small groups, discuss board or committee business, and then communicate the discussion to other members. They should not send emails or text messages to a quorum of members regarding official business, even if each email is addressed and sent to each member individually. Should not create posts on social media about board business where likelihood exists that a quorum of members could participate in discussions, or ask a quorum of members, even on an individual basis, for feedback or comments on board or committee business outside of the public meeting. This is also called polling, which is essentially conducting an informal vote on an issue. Some guidelines for open sessions. A board or committee is limited to discussing the specific items on the agenda. During the public comment portions of the meeting, members of the public are given an opportunity to speak, and the presiding officer may set reasonable limits on commenters. A member of the public or a member of the board may raise a subject that has not been included in the agenda. However, any discussion of the subject must be limited to a proposal to place that subject on the agenda for a future meeting. Further best practices. To avoid violating the act on the basis of insufficient notice, the members should limit discussion to specific agenda items contained in the posting filed with the Secretary of State. Avoid allowing discussions regarding specific agenda items to wander off course into new issues that have not been noticed to the public. Should not respond to or discuss issues that are raised during public comment but which are not on the agenda, and specifically identify for future agendas and communicate those items to TDLR staff. There are actually penalties associated with violations of the Open Meetings Act. We'll go into those a little now. First, there's a set of civil remedies. Any interested person, including the media, may petition the courts to stop actions taken in violation of the Open Meetings Act. The Open Meetings Act also specifically states that an action taken in violation of the act is voidable. There are criminal penalties associated with Open Meetings Act violations. Members who knowingly participate in a walking quorum or who knowingly participate in a meeting that is closed to the public are subject to misdemeanor criminal penalties. The penalties are a fine of $100 to $500, confinement in county jail for 1 to 6 months, or both the fine and jail time. Again, best practices: avoid communications that involve a quorum of board or committee members about official business outside of a properly noticed public meeting. And during open meetings, confine discussion to items specifically posted on the agenda. Open Meetings Act is a complex and frequently litigated area of the law. If you're interested in further research, we've provided some links, especially the Texas Attorney has some great materials that kind of go into more detail about the intricacies of this set of law. Next, we'll move on to the second major statutory authority, the Administrative Procedure Act. The purpose of the Administrative Procedure Act is to establish minimum standards of uniform practice and procedures for state agencies and to provide for public participation and transparency during the rulemaking process. The APA defines a rule. A rule is a statement of general applicability made by a state agency that implements, interprets, or prescribes law or policy, or describes the procedure or practice requirements of a state agency. A rule excludes, that is, does not include, a statement regarding only the internal management or organization of a state agency and does not affect private rights or procedures. A rule does include a new rule, an amendment to an existing rule, and the repeal of an existing rule. There are multiple sources for potential rulemaking: legislative changes instigated by the Texas legislature, suggestions by the advisory boards, suggestions by TDLR staff, the 4-year rule review, which is conducted of all Texas administrative rules under the department's regulatory jurisdiction, and also rule petitions. A rule petition allows any interested person to submit a petition to a state agency requesting the adoption of a rule. An interested person is defined as anyone who is a Texas resident, a business entity located in Texas, a governmental subdivision in Texas, or a public or private organization that is not a state agency, but is located in Texas. This next slide is is a flow chart that goes over the major steps of the rulemaking process. You can see it starts with rule idea and drafting, internal review and analysis. Next step, once we complete a draft of the rules, we send them to the governor's office for their approval. So to get to the first advisory board meeting, move to we move through the publication process, the review of the public comments. Then once we receive all the public comments, we come back to the second advisory board meeting, which will be a few months down the line. And then if these are approved by the advisory board, we present them to the commission. If the commission approves them, we file them with the Texas Register, and on the date that they are published in the Texas Register, the rules become effective. Also, here is a brief overview of that 4-year review process that I was referring to earlier. Every 4 years, all the Texas administrative rules under our regulatory jurisdiction are reviewed to make sure they're still current and they don't need improvement. If we find anything that needs changing, we publish a notice of intent to review. Public has 30 days to comment. We make a recommendation to the commission, and then the commission either adopts the rules without changes or changes suggested by the advisory board or by the department. Again, the complex and again, frequently litigated area of the law. Here are some additional links if you are interested in researching this, the APA further. Finally, the Public Information Act. The Public Information Act, or Open Records Act, is intended to allow public access to information about the affairs of government and the official acts of public officials and employees. The Act makes all documents, records, and other information relating to official business open to the public, with some exceptions. Public information includes any electronic communication created, transmitted, received, or maintained on any device if it is in connection with official agency business. The Act should be construed liberally in favor of granting requests for information. We'll talk briefly here about requests for public information. The public may request copies of public information or request to inspect the information in the offices of the governmental body. The request must be submitted in writing. With TDLR, the request must be submitted through our online open records portal, the TDLR Record Center, which can be accessed on the TDLR website. There is some pretty stringent deadlines imposed by the Public Information Act. TDLR must respond to the request as soon as possible, but not later than 10 business days after receiving the request. We can't ask why someone wants them. We can only ask for clarifications through the GC Open Records team. So the general rule is a presumption of openness, though there are some common exceptions to this rule. Certain information is required to be redacted from open records. Examples includes date of births, most email addresses, driver's license plates, VIN records, credit card numbers, and any medical information protected by HIPAA or the Texas Medical Records Privacy Act. An OAG must be sought to redact or withhold other OAG ruling, must be sought to redact or withhold other information. This happens occasionally that you and your role as an advisory board member might receive something that looks like a request for open record. As an advisory board member, if you receive a written request for records or correspondence that looks like a public information request, please forward the request ASAP to the advisory board team, who will forward it to the Office of General Counsel Open Records team. If the GC Open Records team requests information from you as an advisory board member, please respond as soon as possible. The 10-day business deadline applies to all requests, no matter how received. And we've included some additional links if you're interested in investigating this the statute further. That concludes my presentation. I know that's a lot of information in a short amount of time. I'm happy to answer any questions as best I can.
Any questions for Chris? I'll reassure you that, yes, it's a lot of information, but all of the information that happened to be on the slides that Chris was showing us is in the board packet that Angelica sent out to us a couple of weeks ago. So if you'd like to go over it all again on your own time and reflect on what he said, it's all there for you. Anything else, Chris?
That's all right now. Thank you.
Okay. Great. We're moving on to item D on our agenda is approval of the minutes from our last meeting, July 28th, 2025. You received those minutes in the board packet that Angelica mailed to all of us a couple of weeks ago, or emailed to us, sorry. Are there any comments or questions about those minutes? Hearing none, I would accept a motion to approve the minutes.
I'll motion to accept the minutes. Norma
And
Weems.
thank you, Norma. It's that reminder about saying who you are. It's hard. So moved by Norma Weems, and do I hear a second?
Second, Stacy Poteet.
Thank you, Stacy. We have a motion and a second. All in favor, we're going to do a roll call, and Angelica will ask you for your vote.
Thank you. Stacy Poteet,
Aye.
Dr. Eduardo Perkin,
Aye.
Robin Tellez,
Aye.
Norma Weems,
Aye.
Dr. Shauna Jackson,
Aye.
and I think Miss Andrews dropped off. Presiding Officer Sherry San Cyprian.
Aye.
Motion passes.
Thank you, Angelica. Item D on our agenda is public comment. We have Alice Carter representing herself. She is joining us. Welcome, Ms. Carter. Ms. Carter, thank you for being here. When you begin speaking, please state your name and who you represent. You have 3 minutes to speak. And please understand that board members are not allowed to ask any questions or engage in discussion with you. Do you understand these instructions?
Yes, I do.
And you have 3 minutes. Angelica will keep time. Please start whenever you're ready.
Hello, my name is Alice Carter. Thank you for allowing me to participate in your meeting this morning. Excuse me. I'm asking the commission to reconsider the requirements for SLP assistant licensure. I am in particular asking you to reconsider the supervised clinical hours required for SLP assistant licensure for individuals who were previously licensed and practicing SLPs. I graduated from Columbia University with a master's in science in 1992. From then on, I worked as a speech-language pathologist, beginning with a clinical fellowship year for 9 months. As with all SLP licensure, a certificate of clinical competence is required, issued by ASHA. This is a mentored professional experience following the completion of SLP academic coursework and clinical practicum. This meant that for 9 months, all my clinical work was directly supervised by a fully licensed SLP. After over 25 years of clinical practice, I retired as an SLP. I no longer hold an active license as an SLP. About 8 months ago, I began to think about returning to the profession in the role of an SLP assistant. I thought about working with younger, fully licensed professionals in the school setting, an arena I know so well, but this time as a helper. As an assistant, I understood I would be carrying out the plan of care created by the SLP following their full evaluation of the student. I relished the thought of working in a supportive role with beleaguered school-based SLPs whose caseloads are notoriously large. As for me, this made perfect sense as a part-time job. I did everything required for the assistant licensure, the jurisprudence exam, fingerprints, academic transcripts, and even sent in evidence of previous licensure, including continuing education evidence over the course of 25 years. SLP assistant licensure requires a BA, as you know. I have an MS and 25 years of experience, but was still informed that I needed to satisfy 50 hours of clinical supervision before an assistant license would be issued. It was at this point that I went to the office of the TPLR and met with a representative there who said the only way to address my concerns about this requirement was to appear before this committee. I waited until now to do so. To me, it is contrary to the public interest to put up obstacles in the path of older and more experienced professionals who wish to fully support licensed SLPs. I would venture to say that there are more people like me who could step into these roles, save the state money, and most importantly, provide a high level of service to our students in concert with the hardworking SLPs in the school setting. In closing, I'm asking you to waive the clinical supervision requirement, excuse me, of SLP assistants for those of us who have previously been licensed and who have had CCs for years. We have a lot to offer and everyone benefits when you use this valuable resource. Thank you for your consideration.
Thank you for sharing that request with us, Ms. Carter. As I mentioned, we cannot discuss it today, but we can certainly put it on an agenda for future.
Thank you.
We are on to item F, the staff reports, and representing the licensing division today, we'll have Regina Horton.
Good morning, advisory board members. My name is Regina Horton. I'm the team lead for the health professions team, and I will be providing the statistics to you today for the speech language pathology and audiology program. You should have a copy of the report in front of you to follow along. For the first quarter fiscal year 2026, we issued 216 speech language pathology licenses. We renewed 1,838 licenses. There were 1,828 licenses that renewed online with 99%. The total population is 19,368. For our speech interns, we issued a total of 88 new licenses. 28 licenses was renewed with 100% renewing online, and the total population is 1,048. For our speech assistants, we have issued 164 new licenses for first quarter fiscal year 2026. We renewed 513. 510 of those licensees renewed online with 99%, and the total population is 5,514. For audiologists, we have issued 19 new licenses, 171 licenses renewed with 170 renewing online. That's 99%. The total population is 1,654. Audiologist interns licenses, no new licenses was issued, but we did renew 3, 100% renewing online, and the total population is 64. For audiologist assistants, we issued 8 new licenses. We renewed 9 licenses with 100% renewing online, and the total population for that is 77. This concludes my report. Do you have any questions?
No questions? Thank you, Regina.
Thank you.
The Education and Examination Division, represented by Michael Ford Strong today.
Good morning, Chair and members. My name is Ford Strawn. I'm the new director for our Education Examination Division. Proud to be here today. Thank y'all for y'all's time. What you see in front of you is our division's report for our jurisprudence examinations. E&E and TDLR do not have our own written examination. As you all know, there's a written national examination, so we would not have those statistics in front of us. But if you look at what we have for Q1 and Q2, we are currently on pace, kind of exceeding what we had for last fiscal year, each of these quarters. And if you'll scroll down to the remainder of my report, please. Thank you. And then the last thing we wanted to talk about was just continuing education requirements for our audit process. As you all know, speech language pathologists are required to obtain 20 hours of continuing education, 2 CE units. And essentially what this is saying is that we have an audit process where I have staff that are requesting upon renewal proof of your continuing education that was completed. What we're asking everybody to do is make sure that when you come up for renewal, you will receive a notification by email or by mail and letting you know that you were selected for audit. If you do have that, first of all, make sure you have retained your records. And number 2, make sure you follow up with that so that you can be cleared of the audit, make sure that your license and everything is not going to be impacted for your next renewal. We're not holding up your renewal during this audit, but certainly we want to make sure that you don't get caught for the next one or start getting more and more letters letting you know you have not completed this action. And there's more information on our website and within that letter over every single detail about how to comply with your continuing education audit at that point in time. With that being said, that concludes my my report, and I'm open to any questions you have.
Ford, at the Texas Speech and Hearing Association's convention, there were a lot of positive comments about the new rule to say that the request for your CE records comes after you've renewed your license. Have you guys gotten any feedback about that?
Yeah, you know, everybody's always excited that if there's something that potentially does not hold up their renewal, I think that always, you know, speaks well to everybody out there. And in line with what we're always trying to accomplish at the agency to get people licensed quicker, make sure they're not impacted, so they can go out there, feed their families, get to work, and everything. But also, we want to make sure that we're doing a good job, diligent job of making sure that people do get their CE at the same time. So we love hearing the great feedback and look to serve y'all however we can.
Good. Yeah, I think that was a good change for us. So, Customer Services Division, Patricia Martinez Castellan. Hi, Patricia.
Hi, good morning, advisory board members. My name is Patricia Martinez Castellan. I'm a manager in customer service. I'll be sharing our contact statistics from fiscal years 2025 and 2026. For FY25, we saw consistent contact volume with some notable increases in January and a peak in August. This is likely tied to renewal cycles. The program received a total of 21,025 contacts with monthly volumes ranging from about 13 to 2,500. Our report is broken down by call and email contacts. However, as you can see, most contact interactions are handled by phone. In FY26, volumes are trending slightly lower and more stable compared to last year. To date, we've only recorded 6,694 contacts. September and October have been our highest so far, and they saw around 13 to 1,400 monthly contacts each. That concludes the customer service report. Please let me know if anybody has any questions.
Patricia, do you know what the average turnaround time is when people email, when licensees email questions?
It really just depends on the influx of emails on that particular day. Emails do come into a queue that has all programs combined. So we don't filter for specific ones. We just handle them in the order that they're received. But right now we have a backlog of about 5 to 7 days.
Okay.
We're working on it.
Yeah, I'm sure it's a never-ending issue, right?
Yeah, it definitely fluctuates. Sometimes we try to shoot for at least a 48-hour response time, but we do work them as we receive them.
Any other questions for Patricia? Okay, moving on to enforcement, and Shauna Elmashuk is presenting today.
Good morning, advisory board members. My name is Shauna Almashuk. I'm a prosecutor for the Enforcement Division. I'll be presenting the report for you today covering key statistics and case highlights. As you may recall from the last meeting, at the top you have the division's performance measures where you can see that there was an increase in cases opened this year from last year. The next section is the criminal history review for applicants who may have disqualifying criminal history. And as you can see, there was a criminal case opened in this same time frame as compared to last year, which resulted in 1 license denial. And then in the next section, it details where the enforcement division's complaints come from. And the top of the next page puts this into a pie graph for you. And as you can see, a majority of the complaints do come from the consumer. Below that are our orders issued. And you can see there were 3 orders this time compared to last year. There was an agreed order, a default order, and an emergency order. And if we jump down to the bottom of this page, you can see that there is 1 license that has been suspended. And at the top of the next page, you can see that the cases closed without disciplinary action still seem to fit into the same categories as the last fiscal year. And then just below that, you can see all of the violations that were alleged at opening, with a large majority being related to ethics. And then finally, I've added 2 case highlights to your packet to provide an example of complaint cases that were resolved by department staff for your review. I'm available to answer any questions that you might have.
Thank you, Shauna. For our new board members, it's always going to be interesting for you to see the kinds of things that licensees do that might make them come across Shauna's desk. So I think we stay pretty standard. Code of ethics violations being a big one, just because there are many things covered under that.
Of course.
And then some of the other random things that involve people who get into the process and then don't follow through or let something drop.
Exactly.
Okay, questions for Shauna, anybody? All right, thank you, Shauna.
Thank you.
And our compliance division, Erica Rodriguez.
Hi, good morning, presiding officer and board members. My name is Erica Rodriguez, and I will be providing our compliance staff report for today. I'll go ahead and begin with our personnel update. We had Ari Acevedo join our health and wellness team in August. We recruited Ari from our education and examination division. She's been a great addition to our team, and she's going to serve as my backup for the program. I'll move on to our current projects. We're currently implementing several bills from the 89th legislative session. While several bills impacted TDLR's health and wellness programs, a couple directly affected our speech language pathology audiology program, which was Senate Bill 905. There were several key changes. First, it simplified the rulemaking process for hearing instrument sales by removing the previous requirement for co-approval with the Hearing Instrument Fitters Dispensers Advisory Board. This just allows us to update our rules more efficiently. Second, it removed provisions related to provisional licenses. Senate Bill 905 also revised education requirements for our audiology licensure. And the third change is it now allows any licensed physician, not just specialists, to authorize hearing instruments for minors. This just aligns with the federal law and improves access for families. Another bill that affected our speech language pathology audiology program is Senate Bill 571. This reduced the reporting timeframe for suspected child or elder abuse from 48 hours to 24 hours. Some other projects that we're currently working on is we are working with our licensing division to update all of our forms, our website, and also our online system to align closely to the recent rules that were effective in December. We're just about done with these updates. These changes are due from the 4-year rule review. Following those changes, I did provide an internal training to our customer service division this past week. That was just to walk them through the updates, just so we can all be on the same page in regards to these changes. Finally, we continue to assist other divisions and respond to daily industry questions and emails. For outreach, I had the pleasure of co-presenting at the TISHA annual conference in Fort Worth this past February, alongside our presiding officer, Ms. Sansaburian, and our licensing deputy director, Katie Bryce. In addition to conferences, I'm also continuing my university tour, presenting to both graduate and undergraduate students across the state, both virtually and in person. Regarding our publications, we continue to work on the TDLR Health Monitor newsletter with our most recent edition published February 23rd. And links to the past editions can be found under the TDLR main website under agency newsletters. We're excited to attend the NCSB annual conference. That's going to be in Denver this October. And if anyone has any outreach opportunities or presentation requests, please feel free to reach out to me, Erica Rodriguez, and I'd be happy to get those scheduled. This does conclude my report for today. If anyone has any questions, I am available to answer them.
And Erica, thank you for doing those university presentations. I think it helps the students to hear directly from the office. It's the first time for them, many of them, to deal with licensure, and our licensing can be just a little bit complicated since we have so many different levels. So I think it really helps them. Appreciate that.
Thank you.
Any
It's my pleasure.
Questions for Erica? No. Okay. The last staff report is an agency update, and we're going to hear from our chief of staff. Susanna, would you like to give your report?
Yes, good morning, Chair. Good morning, members, and welcome to those of you who are new to the board. The purpose of this report is to give a high-level update from the executive office. I am the chief of staff, and at the last board meeting, at your meeting in July, I referred to the agency's acquisition of the lottery and charitable bingo programs. So that transition is complete. We now serve over 1 million licensees, and our FTEs have grown to just over 900 positions. Our the lottery acquisition is, didn't give a lot of detail in July, but let me tell you a little bit more about those programs. In FY25, they generated 1.8 billion for the state of Texas and 7.91 billion in total sales. This strong financial contribution comes despite significant market challenges and new consumer protection measures. The lottery programs primarily service public education. 1.77 billion was contributed to the Foundation School Fund, and a record 31.1 million was provided to the Fund for Veterans Assistance. Senate Bill 1036 during the last legislative session created a new program at TDLR, and that is the regulation of residential solar retails, and it has begun implementation this year. So TDLR now has they have oversight of 41 programs and 1 million licensees. In FY25, the agency fielded more than 12,000 consumer complaints and conducted more than 7,000 investigations, resulting in more than $800,000 in restitution for consumers. Strategic planning for the next biennium is underway, and this document will serve as an important roadmap for the next 4 years, 2027 through 2031. Staff plans to hold virtual public meetings in San Antonio, Houston, and DFW in April. Those dates and locations will soon be made available on our website and social media. Additionally, there will be a virtual public meeting that we'll host in Austin, and that is scheduled for April 15th. So please be on the lookout for additional information and the exact locations of those regionally based strategic planning meetings. As you all are likely aware, our TDLR Core program, implementing all of our licensing systems into one, is now picking up pace. This is a 3-year project consisting of waves of implementation. So when all information is in one system, it will be more efficient and more modern. We'll have greater enhancements and modernizations for our licensees. The first wave is complete with the establishment of a new internal staff-facing portal with one program currently being live. 2 more programs are scheduled to go live at the end of April, with successive wave launches scheduled throughout the program's completion. What I have today for the executive update. If there are any questions, I'll be happy to answer them. Thank you.
Thank you, Susanna. Do you anticipate any disruptions in services as each program moves on to the new database?
No, we're doing a great deal of internal testing and ensuring that all of the kinks are worked out before those go live and publicly facing.
Good luck to everybody managing the million licensees. And I know our 20,000 thankfully are not contributing too much to the 7,000 investigations every year. So we appreciate that. Anything else for Susanna? Okay, thank you. Next on the agenda, Chris Funderburg is going to lead us through some proposed amendments that we'll need to review and listen to what Chris has to say. And then at the end, we'll need a motion so that we can a motion to publish this content in the Texas Register because it goes out for public comment. So listen to Chris's description, and then we'll be asking someone to make a motion and someone to second. Chris?
Thank you, Presiding Officer Sid Cibrian, and thank you, board members. I'm going to share the proposed rule package right now. Please let me know if you can see that. Should say Chapter 111, Speech Language Pathologists at the top.
I can see it, Chris.
Thank you. All right. Again, I'm Assistant General Counsel Chris Funderburg. The proposed rule package I'm presenting today is a relatively simple modification of Texas Admin Code Chapter 111, the administrative rules governing the speech language pathologist and audiologist program. The impetus for these rule changes were several bills passed by the state legislature during its 2025 session, specifically Senate Bills number 904, 905, and 2075. They also include amendments suggested by departmental divisions during the 4-year rule review of Chapter 111, including the Licensing Division and Compliance Division. Erica gave you a preview of these changes during her Compliance Division presentation, and we'll go over them again now. So the first major change made by the proposed rules is to eliminate the definition of provisional licensee from the definition section in 111.2, as provisional licenses are no longer needed now that the jurisprudence exam is always available. Next, the rules amend, I'm just going to go say .12 and .13 subsections that govern the requirements of the terms of the members of the speech language pathologist and audiologist advisory board. These amendments remove language that would require the 6-year terms of the 3 members of the advisory boards to expire on February 1st of each odd-numbered year, and change the advisory board's presiding officer term from 1 year to 2 years, and also allow the advisory board members to serve their full 6-year term, regardless of when they were appointed. Next, the proposed rules make several amendments to .50, the subsection that governs the educational and clinical observation and experience requirements for individuals seeking licensure as an assistant in speech language pathology First, the proposed rules now require that if any of the 25 hours of clinical observation and 25 hours of clinical assisting experience required for licensure as an SLP assistant were earned during training, then this verification must be submitted to the assistant's supervisor after the license is issued. Next, the proposed rules also amend .50D1 and clarify that the requirements of 50D1 are prescribed by 50D and not 50E. Finally, the proposed rules also reorganize the requirements of .50D and .50E in a more logical manner. Specifically, the proposed rules move former .50E to .50D3, move E1 to D3A, move E2 to D3B, and move former 50D2 to 50E. It probably makes more sense reading it than it does speaking it, but I think you can see that this that the rearrangement doesn't change any of the substantive requirements, but rather just kind of arranges it in a more logical and procedure. The next set of requirements, the next set of amendments, rather, are made to 111.55, the subsection that governs the application and eligibility requirements for an assistant in speech language pathology. First, the proposed rules repeal section, .55B5, and remove the requirement that applicants for licensure as assistant in speech language pathology must provide the department verification from their university program that the applicants complete 25 hours of clinical observation, 25 hours of clinical assisting experience. This is kind of a mirror of the changes that were made in .50 earlier. While the verification of this 25 is still going to be required, but now the obligation for maintaining those records falls onto the university representative rather than the department. Next, the proposed rules also repeal subsection .55B6 and remove the requirement that applicants who did not obtain all 25 experience complete those hours under direct supervision by an approved supervisor after the license is issued. Finally, the proposed rules renumber 555B1 through 8 to accommodate these amendments. Next, the proposed rules amend 111.70, the subsection that governs the licensing requirements for an audiology license. First, the proposed rules amend subsection 70B and now authorize an applicant seeking licensure as an audiologist to qualify if the applicant possesses a master's degree in audiology confirmed on or before December 31st, 2007. Next, the proposed rules amend C1. These amendments now require an applicant who earned a master's degree in audiology at a foreign university on or before December 31st, 2007 to hire a transcript evaluation service to determine that the applicant's degree is the equivalent of an degree obtained from a program accredited by a national accrediting organization. Finally, the proposed rules amend 111.220, the subsection which governs the sale of hearing instruments. Specifically, the proposed rules repeal 2.220A, which requires the TDLR Commission adopt rules governing the sale of instruments with both the assistance of the Speech Language Pathology and Audiology Advisory Board and the Hearing Instruments and Fitters and Dispensers Advisory Board. Now, each advisory board can adopt rules governing the sale of hearing instruments in their own profession without having to seek joinder from another advisory board. And that is all the amendments proposed by this rule package. As I mentioned, it's relatively straightforward and uncontroversial, I hope. If you have any questions, I'd be happy to answer them. And if you'd like to suggest any changes to be made to this proposal, now is a great time to do so. There is one additional caveat this board should be aware of. The rulemaking process requires all proposed rule amendments to be reviewed and approved by the governor's office prior to publication. Office of General Counsel sent these SPA amendments to the governor's office on March 2nd, but we haven't heard back yet. If the governor's office proposes any changes, they're likely to be minor. If that office doesn't propose any changes or the changes that they propose are non-substantive, then we'll publish the rules in front of this board for public comment as is or with those minor changes. But if the changes proposed are substantive enough that we think this board should have an opportunity to review those changes during a public meeting, we'll defer publishing the rules in the Texas Register. Instead, we'll bring those modified rules back for review at our next meeting and then submit the rule package for publication. While that possibility does exist, I doubt it will be necessary. In conclusion, if you approved of the proposed rule text that you reviewed for this meeting, then I'd like to ask the board to make a motion and a second to approve these rules for publication in the Texas Register for public comment, which is the next step towards their enactment. I'm happy to answer any questions that you might have.
Any questions for Chris?
I have a quick question, Sherry. It's Shauna Jackson. What we heard from earlier public comment, I know we're not debating that issue. However, is this an appropriate time where I was looking under the suggested changes under audiology assistant licensure, the Part E, and it says held an assistant license in another state. I'm wondering, is it appropriate to add an assistant license or licensed SLP in another, previously held an actual SLP license? Because I do see that what she was referring to, that is left out of this language. Is it appropriate to add that at this time before we submit this for public comment?
Chris Bennebush, General Counsel.
Uh-huh.
I think the proposal that was, first of all, I think we should probably, since we're kind of getting away from the agenda item the agenda that's been published for the public review, what I would recommend doing is adding that to the agenda for the next board meeting, which we're going to be having to have fairly soon if these are approved for publication, since we require first an additional approval by the advisory board and then there's subsequent approval. So
Okay.
we'll be having meetings pretty frequently for next quarter or two. I think that there's also there's an agenda item that I'm going to suggest later on during the meeting that would also require some rule revisions. So my guess is that what you're suggesting can also be incorporated into that new rulemaking as well. But if you'll just go ahead and bring that up when presiding officer asks for suggestions for agenda items, we can certainly add that.
Okay, thank you.
Thank you.
Thanks, Shauna. Anybody else have a question or comment before we ask for a motion? If there are no questions, then I would entertain a motion that we publish these rules, or that we recommend that the rules be published in the Texas Register for public comment.
I move that the rules be accepted.
Moved by
Ms.
Sharice
Andrews,
I'm sorry, yes, Sharice Andrews.
and seconded. Do I hear a second?
Norma Weems, all second.
Thank you. Moved and seconded. Angelica will do a roll call to take our votes.
yes, ma'am. Stacy Boutique,
Aye.
Dr. Eduardo Perkin,
Aye.
Dr. Robin Tellez,
Aye.
Norma Weems,
Aye.
Sharice Andrews,
Aye.
Dr. Shauna Jackson,
Aye.
and Presiding Officer Sherry San Ciprian.
Aye.
Motion passes.
Correct. Thank you. Chris, you're also down for the next item on our agenda, the updates from ASHA's continuing ed.
Yes, and I believe there was a member of the board that wanted to speak on that further.
Okay.
Was my understanding. Elizabeth, did you want to weigh in on this point, or?
No, it was a member of the public that had messaged us about aligning the department's rules to reflect ASHA's recent amendments to their requirements. And we have checked with our compliance folks and our folks who are substantive experts on that. And I think if Katie Bryce is present, could we ask Katie to speak on that? I thought I saw her earlier. I don't know if she's still in the meeting.
There she is.
Yes, Katie Bryce, Deputy Director of Licensing. The public comment was related to TDLR accepting professional development hours as opposed to just ASHA approved continuing education hours. There are some problems with that as I looked into it, that ASHA's term is for 3 years, ours is for 2 years. So just accepting anything that ASHA, if we were to say that if somebody maintains their Cs or something, that we can accept that as proof of meeting our CE requirements, it doesn't really align. If we wanted to accept professional development hours, there are some things that I believe ASHA accepts as professional development hours that don't currently fall under the topics that we accept for CE. So it's just, I believe it was just up for consideration of if the advisory board thought there was a need to look at our CE rules and possibly change them, or if you all are okay with the way it is currently, is my understanding.
ASHA accepts some professional development hours, things that are not actually continuing ed events, and our rules currently specify actual continuing ed that's gone through an approval process. So our rules are more stringent, and I feel like our rules are not excessive at all, 10 hours per year. Many other professions require more than that. So I don't think it's an undue burden on our licensees, but does anybody else, have you heard something different? Do you see it differently, other board members?
This is Robin Tellez. Yeah, I agree, especially for the field of audiology. Not all audiologists even keep their Cs or their ASHA. So.
True. So it may not really be helpful to accept that anyway. And then, as Katie mentioned, the fact that our license renewals don't align, we have most of ours in our birthday, and theirs are on the chronological year and every 3 years. I think there are way more problems than it's worth, considering that it's really not a huge burden to expect people to get 10 hours of really good continuing ed every year. I think that's more than fair. Okay. The next item on our list, recommendations for agenda items. So Shauna, would you say again what you said a little while ago?
Okay, let me see if I can. I would recommend that we discuss adding under the audiology assistant waiver for the observation hours. It would be under 111.50, observation experience part E. Discuss adding in addition to audiology, speech language pathology assistant licensure in another state, that we also add or discuss adding a previous speech language pathology license.
Yes, thank you. That makes sense. Certainly holding your Cs and holding a full license means you had those hours of observation and clinical experience, more than had them. So that makes sense to add that in there. Other items for the agenda. Chris, there was something else that you mentioned.
Yes, thank you, Presiding Officer. Chris Wunderberg, Assistant General Counsel. I was in the other medical professions that I've been assigned. There's been a movement towards administrative regulations governing the use of artificial intelligence in for behavioral analysis, and I've also hearing instrument fitters and dispensers is interested in developing some rulemaking on this point as well. I was going to suggest that an agenda item be added to the next board meeting to discuss the issue further, and also that in the interim we appoint a work group with interested members, probably I think it'd be a standard of care rulemaking work group, that we can discuss this issue further. We have a set of rules already effectively approved, but not yet published for the behavioral analysis program that I think will provide a good working template for this profession as well. So I think we could probably incorporate Board Member Jackson's suggestion into that rulemaking, so maybe knock out two birds with one stone. But I would to clarify, I would suggest adding an AI discussion, work group discussion, report discussion to the next agenda, and also to appoint members to a work group for the standard of care rulemaking work group, so we can discuss it in the interim.
Okay. Chris, we did work on sort of a draft at some point, I think when the behavior analyst came out with theirs.
Yeah.
So we have a little bit of a start, which then a work group could then hammer out and be able to present at the next meeting.
That's my hope, yes.
Okay. Other items that you'd like to see placed on the agenda for our next meeting? Anything from board members or staff? Okay. If board members, if you think of something outside the meeting, you're free to contact Angelica, and we can look at putting that on a future board meeting agenda. So if those are all the suggestions we have for now, then we won't try to set a date today, but Angelica will poll the board as she always does to find a time that works for at least a quorum. So we'll do that. And then do I have any volunteers to serve on a work group for standard of care specific to the use of AI in our professions? It would be helpful to have
Carrie.
that's pathology and audiology. Yeah.
Since we don't have work group assignments on this agenda, we can't
we
assign one
can't do
just
it
yet.
today.
So we'll do that on our next meeting agenda. We'll
Okay.
assign folks to each work group, and then we can assign that specific agenda item to that work group.
Okay, so we'll have to wait until the next time to do that. Okay, we'll be thinking about it because we'll ask for volunteers then.
Yes.
Right. Any other board business that was on the agenda that we need to take care of?
Presiding Officer Elizabeth Salinas, Strict Matter General Counsel. I just wanted to say hello to the board and congratulations to the new board members. I'm a 23-year practicing attorney, and I've been with TDLR for 9 years. As Chris mentioned, we recently reshuffled our programs so that folks newer to the General Counsel's office could get some experience on high-profile sort of programs, but also so the older folks like myself can have an experience, can be able to broaden our knowledge of the various programs within TDLR. So I just wanted to say hello. Thank you for your service, and I look forward to working with all of you.
Well, thank you, Elizabeth. Welcome to the team here, right?
Thank you.
Good. Okay, if we don't have any other business, then thank everybody for participating today. Welcome to the new people. Go back and look at your board packet again. Some of it will make more sense now that we've talked through a lot of it. And it's a learning curve to just figure everything out about board service. Helga's a great resource, and she can always guide you if you have questions about our meetings or things that are expected of you. So, and I will adjourn this meeting of the Speech Language Pathologists and Audiologists Advisory Board at 11:05. Thank you.